what percentage, or if we could do the percentage, or, how much of this is on the lender and how much of it is on the borrower?
Well, I would say 100% of the analysis should be on the lender because it's their capital going out. Mm-hmm. It is for the lender to ask the right questions. Now, if a borrower misrepresents something or miscommunicates something, that can lead a lender to make decisions they wouldn't otherwise make. But a smart lender, has to ask all of the right questions and really know their audience. So we've been doing this for almost 8 years. We have relationships either as borrowers or just as friends with the firms that filed the first cases in almost every tort, the ones who settled almost every major tort in the last 6 or 7 years, and the ones who really have the information on, I don't mean confidential information, but they know what they're doing. They have information to let them make good decisions. So if we say, are you looking to joint venture with others? If you are, let us know. We trust them. But to answer your question directly, I think the lenders bear the responsibility for being educated. And there's a lot of money in the space today that does not understand that fully. It's not their fault, but they're not lawyers. They are bankers. And they think having a very, very strong 100-page loan document insulates them. And it doesn't.
Yeah.
It just doesn't. You have to have the relationship and the knowledge and the performance before anything, I think. So.
Yeah. And you personally and your team do a great job with that, with staying in touch and communicating these issues to your clients. So I'm grateful for that, because knock on wood, I haven't had, any issues. There's been maybe one or two exceptions, but generally speaking, I haven't had a firm find themselves in a situation where it didn't work out for them. So I take the same approach, is to understand what the vision is, what the blueprint is, what the business model is. And if I don't hear that a lawyer or a firm has a path to where they want to get and understand all the moving parts, then we don't apply for a loan. We have to start at the basics, and we have to understand, because I know that the lender needs to hear the story. What is the story of the firm? What is the firm trying to accomplish? What is the firm ultimately? What is the impact that the firm needs to make? So I think those are all important things to raise. So where do things go wrong for the law firms? Can you expand on that?
Yeah, I think you touched on one sort of key example a moment ago, that lawyers, they don't plan. They take the money. Virage is not a Monday morning quarterback as much as, trying to be helpful to the firms, but we're certainly not a backseat driver either. We trust the firms that we work with to deploy the capital appropriately. And there are conditions in our loan documents to use the capital for these business purposes that support the firm, the cases, the marketing, all of that. So it's a broad mandate, but it does have its boundaries. And firms who fail to plan, for example, if they borrowed $1 million and they put it all into marketing the next day, and they pledged their personal injury portfolio, they were used to running on 100% of that cash flow. In the Virage model, they will share part of that cash flow, meaning it's a waterfall, right? So part of that cash flow repays their debt, just as they would make a payment to a bank quarterly or when the bank demands it. With Virage, you're not making that payment when you don't have cash flow. But if you get a $100,000 check in, you're going to overage some sum of that. Whether it's 40% or 60%, you're going to overage a share of that to repay the debt. And Virage knows that going in. And so we may say, what do you need to operate? Let's protect that. Do you have enough in excess to service the debt when money comes in? So we work with you, we work with your clients, and we have that discussion early on. So one way lawyers go wrong is giving up on what brought them to the dance to begin with. They take their foot off the pedal on PI, for example, and they are working on mass torts, but they don't realize it's a 5-year payoff. That's one way. The other way is not taking advantage of all of any tax benefits, whether it is an interest expense deduction, whether it is sharing any of the interest. Again, I encourage anybody listening to this to consult with an ethicist in their jurisdiction and or with an accountant or tax advisor otherwise. But with that caveat, there are some lawyers who say, well, I'm in a joint venture. It's 50-50, but it's my money. Well, if you borrowed that money from Virage at an interest rate, are you sharing that 50-50 with your co-counsel? Oh, no, I didn't even think about that. Well, why not? So you have to build your contracts with co-counsel and joint venture partners so that they share it. Now your burden is halved. There are some jurisdictions that permit you in the right circumstances to share some amount, albeit a lesser amount, of some interest expense with a client. Again, just check with your ethicist. It's permissible in the right circumstances. So my point is they fail to plan for their economic future. And they're not taking advantage of benefits that would, inure to really their success in the long term. The other thing that they fail to do, Morena, is they pick the wrong horses. They pick the wrong torts. They pick the wrong jockeys on those horses. And they either have good torts with bad jockeys or, bad torts with good jockeys, or bad torts with bad jockeys. But either way, by jockey, I'm talking about the handling firm that they entrust their cases to. And any one of those combinations will cost you a lot of money. Yeah. And that's why diversifying your portfolio, I tell lawyers that all the time. Don't spend $1 million on one tort. Put $300,000 into 3 torts.
Yeah.